He didn't know he was being recorded. That's the part that still makes me laugh a little, even now. I was 31 years old, sitting in a parking garage in downtown Nashville, and my hands were shaking so hard I had to hold my phone with both of them. Not because I was scared. Because I was done being scared. There's a difference, and I didn't learn it until that afternoon. Let me back up. I met him at a work conference, one of those professional development weekends where everyone wears lanyards and talks about synergy and nobody actually means anything they say. He was a keynote speaker, 53 years old, silver at his temples, the kind of confident that comes from never having been told no. He ran a private equity firm that managed close to $800 million in assets. I was an operations coordinator for a mid-sized logistics company, and I was only at that conference because my supervisor had a family emergency and handed me her registration badge at the last minute. We ended up at the same table at dinner. He was charming in a way that felt earned, not performed. He asked me questions and actually listened to the answers. He remembered what I said 40 minutes later and referenced it back. I wasn't naive. I knew the gap between us. But I was also 31 and tired of being cautious about everything. We exchanged numbers. He texted that same night. For 4 months it was good, not perfect. He traveled constantly and I learned quickly not to hold my breath waiting for plans to become real. But when he was present, he was fully present. He took me to dinner at places I'd never been. He flew me to Chicago for a long weekend just because I mentioned once that I'd never seen Lake Michigan. He was the kind of man who made you feel like the most interesting person in the room, and I was not immune to that. I knew he had been married twice. He told me himself. He said both marriages had ended because he prioritized work over everything, and that he was trying to be different now. I believed him. That's not stupidity. That's just what belief is. You can't do it halfway. I found out I was pregnant on a Tuesday morning in March. I was alone in my apartment bathroom, sitting on the edge of the tub, staring at 2 lines that rearranged every plan I'd had for the next 5 years. My first call was to my sister. My second was to him. He didn't say anything for a long moment. Then he said, "Are you sure?" I told him I'd taken 3 tests. Another pause. Then, "Okay, let me think." He called back 2 hours later and said we should meet in person. I thought that was a good sign. I drove to his condo near Midtown with the kind of hope that you hold loosely because you already know it might break. He poured 2 glasses of sparkling water. I noticed he didn't offer wine, and he sat across from me at his kitchen island and said he'd been thinking carefully. He said he cared about me. He said this wasn't about that. He said he had a certain life, certain obligations, a family legacy that was complicated in ways I didn't fully understand, and that a child right now, with the circumstances being what they were, would create problems he couldn't manage. I said, "What exactly are you saying?" He said he wanted to take care of it. He said he'd pay for everything. He said he knew a clinic that was very private, very professional, and that he would handle all of it, and afterward he would make sure I was compensated for the difficulty. I asked him what he meant by compensated. He looked at me with an expression I can only describe as boardroom calm. He said $250,000, wired within 72 hours of the procedure, and that he'd also cover 6 months of my rent so I had time to stabilize. I set down my water glass. I said, "I need a day to think." He nodded like that was reasonable, like we were negotiating a contract amendment. I drove home, and I didn't cry until I was inside my apartment with the door locked. Then I cried for about 2 hours. Not because of the money, not even because of what he'd said. I cried because for 4 months I had let myself believe I was seeing the real version of him, and what I was actually seeing was just the version he showed when things were easy. I called my sister again. She drove over and we sat on my kitchen floor, and she said, "You know what you want to do." And I did. I had known since the drive home. I just needed to hear someone else say it like it wasn't a catastrophe. I wanted to keep the baby. I didn't call him back that night. I spent the next 3 days doing something I had never done before. I looked up a family law attorney. I didn't tell anyone at work. I didn't post anything. I just made an appointment with a woman named, I'll call her my attorney, whose office was in a low-rise building off Charlotte Avenue. And I walked in there with a folder of printed texts and a very clear sense that I was not going to handle this the way he expected me to. My attorney had handled high-asset family cases for over 20 years. She was the kind of woman who wore reading glasses on a chain and spoke in complete sentences at all times. She looked at my folder of texts, asked me 3 clarifying questions, and then she said something that I wrote down in my notes app the moment I left her office. In Tennessee, a father's financial obligation to a child is determined by income, not by preference. And there is no preference clause in child support law. She told me we should establish paternity as early as possible. I didn't know the prenatal DNA testing was possible. Not all states make it easy to act on, but it can be done. She walked me through what that process looked like and what it would establish on the record. I asked her what child support would look like given his income. She said Tennessee uses an income shares model. She said that at his reported income level, we were looking at a number that would be significant. She said, "This is not a situation where someone writes a check and moves on. This is a legal structure that follows a child until adulthood." I asked her what I needed to do first. She said, "Let him think you're still deciding." I went home and I texted him that I needed a little more time. He replied within 4 minutes. He said he understood, he just wanted to make sure I was taking care of myself, and that the offer still stood. I kept those texts too. About a week later, I got a call from a number I didn't recognize. A man with a very smooth voice introduced himself as an attorney representing the family, not him specifically, the family. That word hung in the air for a second. The family. Like there was a board of directors involved in my uterus. He said he was calling on behalf of my boyfriend's family to discuss a comprehensive arrangement. He said they wanted to make sure this situation was handled with discretion and mutual benefit. He said they were prepared to offer a one-time payment of $1 million, provided I signed a full non-disclosure agreement and agreed not to pursue any legal action related to paternity or financial support. I said, $1 million. He said that was correct and that the arrangement would also include a relocation stipend if I preferred to move to a different city. I said, I need to speak with my own attorney before I respond to anything. He said, of course, that was completely understandable. I hung up and I sat in my car for probably 10 minutes. My first feeling was anger, not at the number, but at the relocation stipend. The fact that someone had thought about it carefully enough to include a line item for making me disappear geographically, that was when it became very clear to me that this was not just one person panicking. This was a strategy. Someone had thought this through. I called my attorney immediately. She was quiet for a moment after I finished. Then she said, "They just handed us something." She explained that the call itself, the framing of it as a family matter, the mention of non-disclosure, all of it established that they were aware of the situation and were taking deliberate steps to suppress a legal claim. She said, "Do not respond to them. Let me respond." 3 days later, my attorney filed a petition to establish paternity. She also sent a formal letter to the family's attorney stating that any further contact with me outside of legal channels would be documented and could be considered an attempt to interfere with a legal proceeding. I heard from my boyfriend directly after that. He called me and his voice was different, not warm, not the voice that asked me questions at dinner. He said I was making a mistake, that I didn't understand the complexity of his family situation, and that I was going to regret pulling lawyers into something that could have been handled simply. I said, I want to make sure our child is taken care of legally. That's all this is. He said, you're going to make this ugly. I said, I'm going to make it official. He hung up. The prenatal DNA test happened at 12 weeks. My attorney had coordinated with a court-approved lab. The process was more straightforward than I expected. It involved a blood draw on my end, a separate sample from him that his own attorney arranged under legal compulsion, and a chain of custody process that meant the results could be used in court. Results came back in about 2 weeks, paternity confirmed at 99.98%. The day I got that confirmation email, I was in the break room at work eating a cup of soup and I read it 3 times on my phone. I didn't tell anyone. I just finished my soup and went back to my desk and sent the document to my attorney. She filed the formal child support petition the following week. The family's attorney responded quickly. They submitted a counterfiling questioning the validity of the DNA testing process, arguing procedural irregularities. My attorney said this was standard delay strategy. She said, they're not questioning the science, they're questioning the paperwork. We'll address it. It took another 6 weeks to clear that challenge. During those 6 weeks, I had my first ultrasound. The technician was moving the wand around and she got very quiet for a second, and then she tilted the screen toward me and said, "I want to show you something." There were two. I lay there in that dim room and I stared at the screen and I thought, okay. This is the thing. This is the whole thing right here. When I told my attorney, she didn't react the way I expected. She just nodded and made a note and said, "That affects the calculation." In Tennessee, child support for twins doesn't simply double, it's calculated based on the combined needs of both children relative to both parents' incomes. With his reported income, which was a matter of public record through various filings, the number my attorney projected was substantial. Not symbolic, not a gesture, an actual legal obligation that would exist for the next 18 years. The family's response to the twin development was a third contact attempt. This time it wasn't an attorney, it was his mother. She called me from her personal cell phone. I don't know how she got my number, and she spoke in the kind of measured, gracious tone that people use when they have always had money and have never needed to raise their voice. She said she wanted to speak to me woman to woman. She said she understood this was a difficult situation. She said her son was not in a place to be a father right now, that he had his own struggles, and that she thought, as women, we could find a solution that protected everyone involved. She said they were now prepared to offer $400,000 per child, $800,000 total. She said it would be structured as a trust in the children's names, so it wouldn't look like a payoff. She said all I had to do was agree not to pursue ongoing support. I said, "I appreciate you calling. I'll pass this along to my attorney." She paused. Then she said quietly, "I hope you'll think about what you're doing to my son." I said, "I think about what I'm doing for my children every day." I hung up. When I told my attorney about that call, she asked if I had recorded it. I hadn't. She said, "Going forward, Tennessee is a one-party consent state. If you receive another call like that, you may record it." I noted that. The next call came from a different number, one of his associates I'd met once at a dinner. He was clearly reading from something. He mentioned a revised comprehensive settlement. He mentioned a confidentiality. He mentioned, almost as an aside, that it might be worth considering how certain information, he was vague but the implication was clear, might affect my professional reputation. I was in the parking garage of my office building. My hands were shaking, like I said at the beginning, but not from fear. I was recording him. He finished his pitch. I said I would be in touch. I hung up. I forwarded the recording to my attorney within the hour. She called me back in 20 minutes. She said this is now a documented pattern of contact intended to dissuade you from legal action. We're filing a motion. The hearing was scheduled for a Thursday morning in April. I wore a gray blazer I'd bought specifically for court appearances. Not expensive, but structured. My attorney sat beside me. Across the aisle, he sat with two attorneys I didn't recognize, in suits that probably cost more than my monthly rent. His lead attorney argued that the child support calculation was based on projected income rather than actual distributions, and that the figure my attorney had presented was not a realistic reflection of his available cash flow. My attorney stood up and said, "Your Honor, counsel is conflating personal income with business cash flow. The respondent's Form 1040 from the last 3 years, which we have submitted as exhibits, reflects adjusted gross income averaging well above the threshold. Tennessee Code annotated 365101 does not allow for voluntary asset restructuring to reduce support obligations after a petition has been filed." The judge, a woman in her 60s who looked like she had heard every variation of this argument at least 40 times, looked at the opposing counsel and said, "Is counsel prepared to address the income documentation directly?" There was a pause. He looked from across the room like a man who had walked into a meeting expecting to give a presentation and found out there was a quiz. His attorney asked for a brief recess. The judge allowed 10 minutes. When they came back, his attorneys proposed a negotiated settlement, a lump sum plus a reduced monthly obligation. My attorney leaned over and whispered the number to me. I shook my head. She stood up and said we were not accepting the proposed settlement and wished to proceed. What happened over the next hour was, in the plainest terms, a methodical dismantling. My attorney had subpoenaed 3 years of tax returns, 2 years of K-1 forms from his partnership shares, and documentation of a real estate portfolio held under an LLC that his own prior divorce proceedings had identified. She presented the judge with a complete income picture that had nothing to do with what he chose to report on any given Tuesday. The judge awarded child support based on the full income picture, for twins, until both children turned 18, with the provision for college contribution review at the appropriate time. The number was not symbolic. He sat very still when it was read aloud. His lead attorney wrote something on a legal pad. I looked straight ahead. Outside the courthouse, my attorney shook my hand and said, "Well done." That was it. No dramatics. No celebration. Just two women standing in the April sun, and one of them had just ensured that two people who didn't exist yet would never have to wonder if they were worth fighting for. The first support payment arrived via the court-ordered disbursement on the 1st of the following month. Automatic. No drama. Like a utility bill. My daughters were born in July, 7 weeks before my due date, which is common with twins. They were in the NICU for 18 days. I slept in the hospital on a fold-out chair, and I ate vending machine sandwiches, and I called my sister every night before I went to sleep. He did not come to the hospital. His attorneys sent a letter 3 weeks after they were born acknowledging the birth and confirming the support structure was in place. I read it once and filed it. I am not going to tell you I didn't grieve something. I did. Not him, specifically. I stopped missing the man I'd thought he was fairly early on. What I grieved was the version of this that could have been normal. Two people who made something unexpected and decided together to figure it out. That version didn't happen. I had to let it go. What I have instead is this. Two girls who share a crib and steal each other's pacifiers and look at me like I'm the entire world. I have a sister who answered every call. I have an attorney who knew the statute numbers by heart. I have an apartment that is too small and too loud and the most mine thing I've ever owned. Someone once asked me, after they found out the broad outline of the story, whether I felt like I'd used the legal system as a weapon. I thought about that for a while before I answered. I said no, a weapon is something you pick up to hurt someone. What I picked up was a structure, a set of rules that existed to ensure children aren't disposable just because their fathers have things to protect. I didn't build those rules, I just refused to pretend they didn't apply to us. My girls are going to grow up knowing their mother didn't take the money. Not because the money wasn't real, and not because we didn't need it. We did, genuinely, in those early months. But because taking it would have meant agreeing, on paper and in practice, that they were a problem to be solved rather than people to be raised. They are not a problem. They are the clearest thing I have ever done. And if he ever wants to be in their lives, the door is not locked. But it opens from the outside on his initiative, and it opens through a family court mediator, and it opens only if they want it to, when they're old enough to have an opinion. That's not cruelty, that's just the boundary between care and control. I learned the difference in a parking garage in Nashville with my hands shaking and my phone recording and the full knowledge that I was not going to be bought. Some lessons you don't forget. I keep coming back to the moment in that parking garage, hands shaking, phone recording, the hum of fluorescent lights overhead. That moment wasn't dramatic from the outside. It probably looked like a woman sitting in her car, but something in me had shifted, and I knew it. And there was no going back from it. Here's what I've come to understand. The outcome of this story wasn't luck. It wasn't that I happened to find the right attorney, or that the judge happened to be fair. Those things mattered, but they weren't the foundation. The foundation was a choice I made before any of that. The choice to treat my situation like something worth fighting for, rather than something to survive quietly. When his family offered money to make my daughters disappear, they were betting on a version of me that didn't exist anymore. They were counting on shame, on isolation, on the reasonable fear that a woman with no resources shouldn't take on people with unlimited ones. And I understood that fear. I felt it. But understanding a fear and surrendering to it are two different things, and I had enough self-respect left to know the difference. That's the part nobody talks about when they tell stories like mine. It's not the courtroom moment. It's not the number the judge read aloud. It's the Tuesday afternoon, 2 weeks before any of that, when you decide, quietly, without witnesses, that you are going to do the hard thing even though it would be so much easier not to. That decision is the whole story. Everything else is just paperwork. I wasn't smarter than them. They had more attorneys, more money, more time, and a century of knowing how to protect what they had. What I had was a clear conscience and a woman on Charlotte Avenue who knew Tennessee code by heart. That combination turned out to be enough. But it only worked because I showed up prepared, not just angry. I did my research. I kept records. I asked questions until I understood the answers. Intelligence in a situation like this isn't about being the smartest person in the room. It's about refusing to be uninformed. It's about learning the rules of a game that someone else assumed you didn't know existed. And then there's the part that took the longest, staying the course when it got exhausting. There were weeks in the middle of all of it when I was tired in a way that sleep didn't fix. 18 days in a NICU, vending machine sandwiches, a fold-out chair, the legal process grinding forward while I was just trying to keep two small people alive. The will to keep going in those moments wasn't dramatic. It wasn't a speech. It was just the next phone call, the next document, the next day. That's what persistence actually looks like, not fire, just continuation. My daughters are going to grow up not knowing most of this story, and that's fine. What I hope they absorb, without being told directly, is the shape of the choices I made, that their mother was not bought, that she was afraid and she did it anyway, that the right thing and the hard thing were the same thing and she chose both. That's enough of a legacy for me.